Okay, good morning. Let's go ahead and get started. So today we are going to talk a little bit about Social Security disability claims for back pain. And before we really get into the weeds and get started, I do want to make my typical disclaimer that this webinar is not legal advice. With disability cases and really with all types of legal involved cases, they're very fact specific. I do not know the specifics of your situation. So this webinar is not intended to serve as legal advice, but is instead intended to serve as kind of a hub of finding information for disability claims specifically related to back injuries. It does not include everything, but it does include a good bit to kind of give you some semblance of understanding where if you're going through the disability process for back pain and you've got some questions, I do hope that this webinar is helpful to you. If you are watching us on the replay, thank you so much for joining. My contact information will be on the replay. Should be below, but also it will be on the very last slide. If you do have specific questions that I can help you with, reach out. It'll have my phone number and my email address. I love to help in any way that I can. Reach out to me, ask a question. If you would like representation, that's fine too. If it's just a quick question, always happy to answer and help when I can. All right, so today we are going to first cover Social Security disability basics, and then we'll shift into talk about the listings, then we'll shift into talk about residual functional capacity, and then we'll close out, like I like to do, with how an attorney can help you with your disability case. A little bit about me. My name is Kaitlin Wildoner. I am the founding attorney of Beacon Disability PLLC, which is a law firm based in Florida, where we focus on helping disabled clients obtain their Social Security disability benefits as quickly as possible so they can focus on getting better. It's a very frustrating process. I get it. Social Security is a federal practice area, so I can talk and provide guidance to individuals in other states, but our practice is based in Florida. Again, contact information at the end if you have any questions. The reason why I don't do questions live on the webinar is because, again, often it is so individualized that providing responses to, a question on a webinar, I would likely need more information than people might feel willing to give in kind of a public forum. So that's why I don't do questions on the webinar, but I am very open to phone calls and emails about specific questions that you've got, especially today as we're talking about the disability cases for back conditions. So if you've got questions, feel free to reach out. A little bit of background on Social Security disability. There are two different programs. There's Social Security Disability Insurance, SSDI, and then there's Supplemental Security Income, SSI. Both programs, as you can see, require that you be disabled for a period of at least 12 months, which means that you are unable to work, unable to engage in substantial gainful activity due to severe physical and or mental impairments. So the difference is the other prong, okay? Both programs require that finding of disability, disabled, unable to work, engage in substantial gainful activity for a period of at least 12 months. With SSDI, you also have to have sufficient work credits. This often means that you have to have worked 5 of the last 10 years, but there are exceptions to that. With SSI, instead of that work requirement, it requires that you have below a certain threshold of income and assets. So the asset threshold for SSI, if you are single, is $2,000. If you are married, it bumps it up to $3,000. That asset threshold does not include one home and one car. As long as you live in that home, you can have that one home and one car excluded from your asset holdings. And there are other exclusions as well, but by and large, it does include most assets, including bank accounts, retirement accounts. If you're a family that has a 2-car garage, not just a garage, but you've got 2 cars in your garage, that unfortunately is often enough to push you out of SSI eligibility. Not always, but often. So those are the differences. With SSDI, you have to have sufficient work credits. With SSI, you don't have to have work credits, but it does have income and asset restrictions on whether you qualify. Turning next to the 5-step evaluation process. When you submit your application for either SSDI or SSI benefits, once Social Security decides that you really, step 0 is, do you qualify based on, if you applied for SSDI, do you have enough work credits? If you apply for SSI, are you below that income and asset threshold? As long as you meet that second prong of either program, Social Security, this is their 5-step, disability evaluation process. So they will first look to see, are you engaging in substantial gainful activity? For 2022, substantial gainful activity is if you are working more than 20 hours a week, or if you are earning more than $1,350 gross before taxes, before health insurance, before any deductions per month. If you are engaging in substantial gainful activity, meaning you are working more than 20 hours a week and or earning more than $1,350 a month in gross earnings, Social Security will stop the evaluation of your claim there, and they will say, by our definition, you cannot be disabled. You are engaging in substantial gainful activity. You are not disabled. Case stops there. That's when you'll get a denial letter. If you are not engaging in substantial gainful activity, then Social Security moves to step 2, and they look at, do you have any severe medically determinable impairments? If you don't, if you have no severe medically determinable impairments, the evaluation again stops there and you'll get a denial letter. If you do have at least one severe medically determinable impairment, Social Security will move to step 3 and they will evaluate, do your conditions meet or equal one of their Bluebook listings? As we'll talk about in a few minutes, there's more than a handful of listings that Social Security can evaluate your claim under to see, do you meet or equal one of these listings? If you do, the evaluation stops there, but instead of resulting as a denial like it did at the first 2 steps, it'll be an approval. If you meet or equal a listing, your case is approved and you're good to go. If you don't meet or equal a listing, Social Security creates a residual functional capacity for you. They will determine, based on your medical records, based on your file, what they think you are capable of doing. They'll evaluate how long you can sit, stand, and walk for, both at one time and over the course of an entire 8-hour workday. They'll also evaluate different postural and environmental limitations. They'll take a look at your mental health and see, are you able to keep up with production? Are you able to interact with others? So they kind of evaluate all of that to create an RFC for you. And based on that RFC, Social Security then looks to see, can you go back to your past work? If you can go back to your past work based on that RFC, evaluation stops, you're found not disabled. If you cannot go back to your past work based on that RFC, Social Security will move to step 5 and take a look at, okay, based on that RFC, based on your age, based on your education, based on your past work, is there other jobs you could do that exist in the national economy? If yes, again, denial. If no, if there's no other jobs that you can do, you can't go back to your past work, that's where you get a favorable decision at step 5. Okay, so that's how the 5-step evaluation process works for the disability side of the claim. Turning to the listings, which is also known as the Bluebook, as you can see here, that's the URL hyperlink directly to the adult listings. There's 2 different kind of Bluebooks. There's the adult listings and then there's the child listings. This one will take you to the adult listings. And if you go, you'll be able to see that the listings cover 14 broad categories. And each of the listings, there's not just 14 listings, there's 14 categories. And each of those categories has usually at least a handful of listings underneath it. Each of the listings contains medical criteria that will apply to the evaluation of impairments in adults. And you'll get to see kind of what that means in a few minutes. Here you'll take a look at, this is the listing of listings under category 1, which is musculoskeletal disorders. And as you'll see, it starts at 1.15, and that's because the musculoskeletal disorder listings changed about maybe a year or 2 ago. And so all cases are now evaluated using these listings, not the prior listings. And in some ways, the listings got a little bit more helpful to us. And in some ways, they did raise the bar a little bit. So I think it truthfully kind of came out to be a wash. They're not necessarily easier to meet overall, but some aspects are easier to meet. So this is a total list of the listings for the musculoskeletal disorders. So this is going to be disorders of the spine, disorders of your hips, your knees. It does also include different types of fractures and soft tissue issues or abnormalities that are under continuing surgical management. So you'll see we'll talk about 1.15, which is disorders of the skeletal spine that result in a compromise of the nerve root. We'll talk about 1.16, which is lumbar spinal stenosis, again compromising. We'll also talk about, I believe we talk about 1.19, which is pathologic fractures due to any cause. And I think that we also will kind of look at 1.21, which is soft tissue injury or an abnormality that's under continuing surgical management. So looking at listing 1.15, it requires a neuroanatomic distribution of one or more of the following symptoms that are consistent with compromise of the effective nerve root. I oftentimes see if you've got a compromise of your nerve root, you will have pain, paresthesia, and muscle fatigue. You often have all three, and if not all three, at least the first two. In addition to that, in addition to the medical evidence that shows that you meet A, you also have to have medical evidence that shows you meet B, which is neurological signs that are present either during a physical exam performed by a doctor or a diagnostic test. And so you'll see there that you've got to have either muscle weakness and signs of nerve root irritation, tension, or compression that are consistent with a compromise of the effective nerve root, and either sensory changes that are evidenced by decreased sensation or sensory nerve deficit on electrodiagnostic testing, or decreased deep tendon reflexes. So one is kind of through a specific type of test, and the decreased deep tendon reflexes can be performed in a standard doctor's office. You also have to have imaging, and on the imaging, there has to be findings that are consistent with a compromise of a nerve root in either your neck or your lumbosacral spine. And finally, part D is what they shifted a lot of these overall, but part D is what they added that kind of can be helpful. Previously, Social Security didn't always consider cane, crutches, walker in making their decision as far as when the listing was involved. So this was added in to this extent. And you'll see that under A, if you've got a documented medical need for a walker, bilateral canes, bilateral crutches, something that helps you ambulate effectively using both hands, that's number one. If you don't have something prescribed or medically documented that you need for your both hands, then you've got to have one hand and then also an inability to use the other. So both upper extremities are being used either by holding on to cane, crutch, something else with just one hand, and then a documented inability to use the other upper extremity. Or if you've got an inability to use both of your upper extremities. So that's how kind of those come into play. And you'll see listing 1.16 has similar considerations as 1.15. Again, you've got to have the medical records. You've got to have the doctor that's supporting you. You've got to have the doctor that's making these notes in your file about the limitations, about what the results of your testing are. It's got to be in your chart. You also, again, have to have either findings on imaging that are consistent with what Social Security would expect to see in this situation, or if you went straight to procedure and they've got an operative report that is, again, consistent with what Social Security would expect to see. Looking at listing 1.19, which is the pathologic fractures, if you've got 3 separate pathologic fractures within a 12-month period, and again, looking at the walker, canes, crutches, and upper extremity usage, you've got to meet both of those in order to meet this listing. And then 1.21 was about the soft tissue injury or abnormality under continuing surgical management. And you can see that you've got to meet all 3 of these. You've got to have evidence that shows that the continuing surgical management directed towards saving, reconstructing, or replacing the affected part of the body. You've also got to show that the surgical management either has been or is expected to be ongoing for at least 12 months, at least a year, and it's got to be continuous. You can't have 6 months of treatment and then you take 8 months off because you think you're better and then you go back for 6 more months. No, it's got to be a continuous 12 months of treatment. And then also it has to be indicated that you have not yet achieved the maximum benefit that they expect you to achieve from the therapy that they're providing. Listing 1108 is not under musculoskeletal disorders, but it does involve the spinal cord. So I did want to address it in today's webinar, and it's for general spinal cord disorders. And to meet this listing, it's not musculoskeletal related, so that's why it's not under that prior category. Listing 1108 requires that you either have a complete loss of function, which is a complete lack of motor, sensory, and autonomic function of the affected part of your body that persists for 3 consecutive months, or you have to have disorganization of motor function in 2 of your extremities, which results in either your inability to stand from a seated position, extreme limitation in your ability to balance while standing or walking, or extreme limitation in your ability to use your upper extremities. And that has to last for at least 3 months. So you've got to meet A or B, or if you have a marked limitation in your physical functioning in one of the following areas of your mental functioning. So you've got marked physical limitation, and in one of these 4 areas of mental functioning listed under C, that if you meet that and that similarly persists for 3 consecutive months after the disorder. All right, so turning our attention to residual functional capacity, when it comes to back claims, you want to make sure your doctor is putting in the record what limitations you have. I often advocate, if you have a patient portal that you have access to, take advantage of that. It can be very, very helpful to have that patient portal to make sure that what you and the doctor are talking about is actually being reflected in the notes that they're going to send to Social Security. Sometimes doctors talk to you about things, they forget to put it in their notes, or they might put it in a different part of the chart that doesn't get sent to Social Security and that doesn't become visible to you as a patient. So try to make sure that you're staying on that, paying attention to the chart, to the notes. And if your doctor tells you not to do something, don't do it. But it's important that Social Security is able to see what your doctor is telling you as far as your RFC. If you've got a doctor that's telling you not to lift more than 10 pounds and not to stand for more than 45 minutes in a day, and they're not putting that in the chart, but you're telling Social Security gets that and they're like, it's not in the chart. It doesn't make any sense. So you've got to make sure that what they're telling you and what's in the chart all matches up. Specific to back pain and RFC, if you've got back pain, you've got a back condition, you might be limited in your ability to stand, walk. If it involves your lumbar spine, you might also have difficulties with sitting. You might have difficulties with lifting and carrying, climbing stairs and ramps, or climbing ladders, ropes, and scaffolds. You might have difficulty bending, crouching, crawling, balancing. All of these limitations and more, you may have mental limitations from your medicine. If the medicine makes it so that you are drowsy and you can't concentrate and focus, make sure that is in the chart, because what you are saying is one thing. I've had many judges, where the client says, yeah, I'm on this prescription and I just can't focus. It makes me very drowsy. I want to fall asleep all the time. And the judge will say, well, have you talked to your doctor about it? And the claimant says, well, no. Talk to your doctor about it, because there might be a different medication that they give you that can provide relief and not make you so foggy or groggy or sleepy. So just make sure that you're having those conversations with your doctor. And again, that those conversations are documented. It may be that the medication that your doctor has you on is what's best for you, and that those side effects are unfortunately just something that we're going to have to learn to grapple with. But it's better to have that conversation with your doctor to confirm that and to put that in the record so Social Security knows that you have had that conversation with your doctor. Everybody is on the same page, aware that that limitation does exist, but that your doctor has determined that that medication is what's best for you because they know your whole picture medically. So kind of, going a little bit deeper, a lot of doctors will not fill out the RFC form, but some will. If you've got a doctor that's willing to fill that out, well, first ask. It doesn't hurt to ask. And when I was growing up, my dad always said, the worst thing someone can do is tell you no, and that's really not that bad. So that's the worst thing that can happen. Go for it. Again, if your doctor just says, no, we don't do that, got it, done. Some doctors will refer you to physical therapy or someone else who might be able to do that. That's a full-blown, usually functional capacity evaluation. You may or may not need that for your case. And if you have an attorney on the file, have that conversation with them. Say my neurosurgeon or whoever, PCP, neurosurgeon, ortho, they're willing to write a script for me to attend an FCE. Do you think that's something I should do? Have that conversation with your lawyer. It might be and it might not be. Alternatively, if the doctor won't fill out the RFC form, but they will put in the chart what your limitations are, ask them to do that. That can sometimes be just as helpful. It's also helpful if your doctor says why those limitations exist for you. Not just, oh yeah, these limitations exist, but why? Why do they exist? What is causing that limitation to be into effect? I have this conversation with clients all the time. It's not enough to have your doctor say you cannot work because of your condition. Social Security looks at that and they say, nope, that's an issue reserved for us. That's an issue reserved for the commissioner. You as a doctor can't make that decision. To me, as a person, that's insane and frustrating, but that's the way Social Security looks at it. That is, under their rules and regulations, an issue reserved for them. So your doctor might think they're helping by putting that in the chart, but it's not helpful. It's much more helpful if they can say why you can't work. What are the limitations that you have that prevent you from working? Are you going to be off task? Can you only sit? Do you have to get up and walk around every 15 minutes? Not just get up and stretch, but actually get up, walk around. What are your limitations? Why do they think you can't work? So that's important. All right, so here is how can an attorney help you? Not an exhaustive list, but we can provide guidance on what correspondence from Social Security actually means. We can file necessary appeals. We will review your medical records and your case file. We can discuss with you what additional records would be helpful for your case. Like I alluded to earlier, sometimes a full-blown FCE might be helpful, and sometimes it might not, depending on what you have in your file. We can help you review your documents for accuracy and completeness. We can discuss what Social Security is looking for in certain specific requested forms that they've got. We work with you to provide relevant updates to Social Security throughout your claim, and we provide updates back to you from Social Security, again, throughout your claim. If you need to go to a hearing, we prepare you for that hearing, and we question you and any witnesses during that hearing. As promised, because I don't take questions live on the webinars, if you do have questions, feel free to send me an email, give me a call. I'm happy to answer any questions that you've got. If you're watching this on the replay, the same goes for you. Reach out, happy to answer any questions that you've got and help where I can. If I can't help, I can try to point you in the direction of someone who can. So thank you so much for joining us, those of you that joined live and those of you that are catching us on the replay. Thank you for spending some time with me. If I can help in any way, feel free to reach out. Take care.